Welcome back to the courtroom, where moments can shift a defendant's future in seconds. Today, we're watching two very different arcs unfold. First, Mr. Orozco, age 34, stands before the court after declining a fresh plea offer. He's frustrated, he feels wronged by SAPD, and he wants the judge to hear him out right now. But here's the twist many people don't realize: a judge can't hear the facts of your case in this setting unless it's a bench trial or a properly scheduled motion. That's going to matter a lot in the next few minutes. The judge will explain the rules, set a plea deadline, and schedule a jury trial date, all while insisting on courtroom decorum. Meanwhile, in a separate matter later, we'll see a probationer asking to remove GPS monitoring. One small weekend Walmart trip could complicate that, unless prior orders say otherwise. Watch how precision, in words, timing, and conditions, determines outcomes. Stick around, we'll break down plea negotiations, bench versus jury trials, what confidential really means in plea talks, how minor violations are evaluated, and why San Antonio's Fiesta even shows up in a probation ruling. Who's in the right? Who's pushing the limits? Let's get into it.
Orozco, it appears we just saw you the other day.
Every day you see me, it's a great
I like the suit again. All right, what are we doing with Mr. Orozco?
Well, Your Honor, the state has tendered an offer. We are respectfully declining that offer. So
Okay,
what just happened is classic docket management. The state tendered an offer today, defense declined today, and the judge immediately moved to a plea deadline and then a jury trial setting. That sequencing protects fairness and efficiency. Plea bargaining is the engine of criminal courts. Most cases resolve that way, but it only works if everyone has time to reflect without derailing the calendar. The plea deadline is a pressure point. Accept by that date, or we pivot to trial. PREP. Viewers, question for you. If an offer lands same day, should a defendant ever accept instantly, or is it smarter to pause and consult? What would you do if the clock starts ticking the moment you hear the number?
The offer tendered today?
Yes, sir. Yes, sir.
How old are you, sir?
I'm 34 years old, miss.
All right, so what I do, I always give people a chance to think about the offer, especially when an offer is just tendered today. So what I'm going to do is I'm going to recall you for a plea deadline date, and then we'll set you for a jury trial date.
You just heard the defendant try to float the 10 years, and the judge cut it off. That's not coldness, it's procedure. Judges aren't allowed to participate in or be exposed to plea negotiations, unless the parties formally invite that involvement under specific rules. Why? To protect the judge's neutrality at trial. If the judge learns offer numbers, rejected terms, or disputed facts outside proper channels, it risks bias or the appearance of bias later. Think of it like keeping the referee out of the locker room deals. Question for you: should judges have more leeway to nudge parties toward a fair outcome, or does that blur the line between neutral umpire and negotiator?
What I was trying to ask him if I can get the 10 years.
No.
Yeah.
The judge does not hear that.
Oh, so here's the thing with, let me explain something to you. Wait a minute, stop, time out.
I got light on.
Time
I got
out.
light.
All right, we're gonna send you out. So I want you to listen to me clearly. It is not my role to hear the facts in this case. What ends up happening, if you go to a jury trial, a jury will hear it. If you want a bench trial, then I will hear the facts of the case. That's how it works. I'm not allowed to hear your plea negotiations with the state and your defense counsel unless they want me to hear that, but that is not allowed. Here's the thing.
The defendant says SAPD lied and harassed him for 2 years, and his anger is spilling into the courtroom, even turning his back to the bench. Here's the tough reality. Allegations about police conduct matter, but there's a time and vehicle to raise them, usually via motions, for example, to suppress evidence or at trial, not informally during a scheduling hearing. Judges have a duty to maintain order and to stay impartial. Disrespect can backfire. It doesn't advance your legal position, and it can lead to sanctions or security interventions. Viewers, if you felt mistreated by law enforcement, would you vent in open court or save it for a targeted legal motion with evidence?
Sir, I understand that you're upset and that you want to be out. I don't know why you're not facing me.
Because I'm mad, miss. Because
Yeah.
SAPD lied to me. They've been harassing me for 2 years.
So does he need an evaluation or no?
I don't believe so, Your Honor. We've been effectively been able to communicate.
Okay. All right. So here's the thing, because SAPD, according to you, lied to you, and because they treated you badly, that is no reason to disrespect the court. For example, the way you're treating me now, guess what? What if I were to say every inmate over there, because you treated me this way, I'm going to treat them badly, or I'm going to treat you badly because you're being disrespectful to the court? That would not be right. I don't do that. So don't do that to me. Do not. Here's the thing.
Powerful teaching moment. The judge says, essentially, don't lay on this court what someone else did. That separates institutional fairness from individual grievances. Courts can correct wrongs, but only through the right channels. It's a reminder that respect isn't about ego, it's about keeping the process clean so your arguments get heard the right way. Strategic tip for defendants. Channel frustration into actionable filings, not in hearing confrontations. Question: do you think judges should respond more empathetically to visible anger in court, or is drawing a firm boundary the better way to protect fairness for everyone?
Do not come to this court putting something on this court that somebody else did to you, because I didn't do it. So what I am telling you, if you will listen, all right, take a deep breath and listen. The state and the defense, they
Crystal clear breakdown by the judge. If you want facts heard now, you'd need a bench trial where the judge is the fact finder, or to a motion like a suppression hearing. Otherwise, facts wait for jury trial. Also, key plea negotiations are confidential and off limits to the court unless both sides open that door. This matters because defendants often believe telling my story to the judge will help immediately. It won't, not at this stage. Think of the process as lanes on a highway. Choose the bench trial lane, the motion lane, or the jury lane, but don't drive on the shoulder expecting a shortcut.
negotiate, and the state offers whatever they offer. The defense will tell you what the offer is. I'm not allowed, because those plea negotiations are supposed to be confidential. I'm not allowed to get involved with that. I know from what you're telling me is that you want to tell me about your case and how these charges never should have been brought, or maybe they should be dismissed. At this point in the process, it is not my job to hear that. I'm not allowed to hear that yet, unless there's a motion to suppress, or unless you want to have a bench trial and you want me to hear it, or either I will hear it when you have a jury trial. That's what I'm trying to tell you. I understand the frustrations that people will have because you're at the jail. You don't feel like you should be at the jail. You don't feel like these charges ever should have been brought. You don't feel like this case should have been indicted if people just had the facts. I understand. I understand your frustration, but do not take your frustration out on the court.
We get timeline context. There was a January setting. Prior appointed counsel fell ill and had to withdraw. New counsel, Mr. O, came on. The state just tendered an offer today. And now the court sets a recall for March 25th to accept or reject. That's the system trying to balance speedy trial rights with real-world hurdles like attorney health and caseloads. If the offer's rejected, the judge promises to get a jury trial set as quickly as possible. Engagement cue. Do you prefer a faster trial with less prep or more time to build a defense, even if it means more waiting in custody? Which risk would you take?
I try to move these cases as quickly as possible. You have been here on January 2024, and then your court-appointed counsel was ill, so he asked it to be removed. So Mr. Arguelles was appointed, and I'm sure he got on your case as quickly as possible. He's just finished a murder trial. The state just gave you an offer today. So what's going to end up happening, and I want you to hear me clearly, this is going to be recalled for March 25th. You can either accept or reject the state's offer. If you choose to reject their offer, what is going to end up happening is we're going to get you a jury trial as quickly as possible. That's how things are going to flow here. Is there anything else?
Nothing for the defense.
All right, thank you. Deputy Laura, why must I raise my voice?
You shouldn't have to, Judge.
Yeah, I'm like,
You know, Judge, sometimes that's the only way they understand. Yeah.
that's what my mom would say with us. And sometimes she would raise her voice, and you know, my brother would say, Now I understand. Johnny, you ready?
Yes, ma'am.
All right, Mr. Aceves. Aceves.
Service.
Aceves. All right. I never know what to do with the V's either.
With what, ma'am?
The V's, you know,
Oh, the
in the
V's,
names to
yeah.
pronounce it correctly.
It's always ve.
Bay, Aceves. Okay. All right, how's
New case, new stakes. Probation asks to remove GPS monitoring because the person has been compliant and stable with employment. Courts typically weigh factors like duration of compliance, any violations, employment stability, community ties, and whether GPS is still necessary for public safety or rehabilitation. GPS can be burdensome, it restricts movement and can jeopardize jobs, but it's also a powerful accountability tool. The prosecution and probation officers' views often carry weight. Question for you: if someone's been solid on probation, when is it fair to step them down from GPS? After 6 months, a year, or only at the very end?
everything going on probation?
Pretty good, man.
And how's the employment?
Also, yeah, also pretty good, yeah.
Okay, awesome. All right, probation. I know they're here for removal of GPS.
Yes, Judge, in reviewing Mr. Aceves' file, it indicates that he's been in compliance with everything. He's doing really well. There's not been any, it hasn't been any violations or anything with his GPS. Everything seems to be going good.
All right.
Your Honor, I have to be honest with the court.
Defense counsel volunteers a possible weekend curfew issue, a Walmart run, thinking the time allowed was later, and he called probation right away. That transparency is strategic and smart. Judges notice when counsel flags issues before the court, discovers them, especially if it's isolated, and promptly corrected. It reframes the narrative, not sneaking out, but misunderstood the window and self-reported viewers. Should a single minor self-reported slip sync a GPS removal? Or does honesty plus pattern of compliance earn trust? Drop your take and tell us if you think curfew terms should be clearer to prevent mix-ups like this.
He did have a violation Saturday or Sunday, right?
This Saturday.
He was out. He should have been home at 2 o'clock or something. He thought it was later than that. So he went to Walmart, I believe.
Yeah.
And that was it. And he called him right away and he went back home. That was it. That's the only thing. And I wanted to be honest with the court because it's going to come in and I don't want the court to think I lied to her.
Okay.
So,
Now, I appreciate your honesty.
well, thank you.
Yeah. And so he was at the Walmart.
Yes, ma'am. Right, Walmart?
Yeah, I was returning
Battery charger.
body charger that I wanted to return.
Okay. All right.
Your Honor, I would like to point out.
Here's the clincher. The court's last modification allowed movement 6 a.m. to 6 p.m., Monday through Saturday, for all purposes, not just work, so that 3 p.m. Walmart trip fits the order. This is a textbook example of why written conditions, control, memory, assumptions, or what I thought, never beat the black and white record. If you're on supervision, keep copies of your latest orders on your phone and in your car. It can save you from a violation spiral. Engagement queue. Should probation apps send push notifications with your current allowed hours and geofences? Would that reduce needless technical violations?
The last time we were in court, we modified his conditions for 6 a.m. to 6 p.m. Monday through Saturday. So it may not be a violation that comes in. We have not received it as a violation.
Okay. What time were you at the Walmart?
3 p.m.
And that was for any purposes.
Yes.
It wasn't just for work or anything like that.
So you were correct. And your, yeah,
No.
I have it here.
All
So,
this time from day one, not one, deleting this one, not one violation, Your Honor.
yes. Yes, and I do have it on my docket sheet that it was for 6 a.m. to 6 p.m.
That's
for
what I
all
thought,
purposes. All right. So do you have any objections to removal of GPS?
No, Your Honor, I did speak to Mr. Aceves briefly. He says that everything's going well with his new job. He feels like everything is going good. So we don't have any objections. at this
All
time.
right. So
The judge greenlights GPS removal but issues a seasonal PSA. Fiesta is coming, and probationers cannot drink. This isn't moralizing, it's compliance triage. Big city events are high temptation zones with alcohol everywhere. For someone on probation, one "it's just a sip" moment can trigger a cascade. Positive test, violation report, hearing, sanctions, maybe even jail. Smart judicial move. Celebrate progress, then pre-coach the risk window. Viewers, do you think judges should tailor conditions around local events, or should rules be one size fits all? And if you were on probation during a festival, how would you plan to stay compliant?
I'm going to remove GPS, but here's the thing. I know this is San Antonio. A lot of things are about to come upon us, mainly Fiesta. So don't get wild and crazy during Fiesta. And remember, you're not allowed to drink any alcohol on probation. And I know Fiesta, it's an alcohol fest, let's be honest. Look, you can walk down the street, everybody booth has alcohol in it. Everybody has those long things with the alcohol in it. Don't get caught up in that, understand?
Yes, ma'am.
All right, so I
really appreciate it, Your Honor. Thank you so much.
Oh, you're so welcome. Thank you. I'm glad you're on track and everything is working out for you. Of course, you have a great attorney. If anything goes wrong or if there are any issues, you can always contact your attorney. If you feel as though probation is not addressing something, you can always come to court and talk to the probation officer here or come to me.
Yes, Your Honor.
All right. So I'll order removal of the GPS.
Thank you, Judge.
All right.
It would be excused.
Yes, we can, but I need to give you all another check-in day because I'm ordering removal of GPS, but I'm going to have you all come back after Fiesta.
Okay,
So we'll come back.
we're gonna have our own fiesta tonight, so tomorrow then.
Okay. All right. So we'll come back May 27. Okay.
Yes, ma'am.
All right. Do you need a reset form?
No, ma'am.
Okay. All right. So we'll be back on May 27th. All right.
All right.
Good
Thank
job.
you.
Thank you. And I like the new haircut.
Judge, it's not nice to talk about hair in front of a bald guy.
2 snapshots, 2 lessons. Case 1. The defendant declined a same-day offer. The judge, guarding neutrality, refused to hear facts or plea terms, set a plea-by date March 25th, and promised a quick jury trial if needed. Takeaway: use the right procedural, lane motions, bench trial, or jury, and keep decorum to preserve credibility. Case 2. A probationer with strong compliance wins GPS removal, despite a questioned Walmart run that ultimately fell within modified hours. Takeaway: details and orders matter. Honesty helps. And seasonal risks like Fiesta can derail progress if you ignore zero alcohol rules. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.